You are in tremendous pain. You are in the hospital. You had surgery recently, and your doctor comes in to talk to you about how you're feeling and to tell you what happened during the course of surgery. Your doctor actually admits that he screwed up. Not in those words, but he admits it and says this should not have happened. If you go ahead and start a lawsuit, can you use the doctor's admission to show that the doctor is liable and responsible for your injuries? Would you like to know the answer? Come join me for a walk along the beach as I share with you that answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You went in for what you thought was a routine surgical procedure. Your doctor said it was no big deal. You'd be in and out the same day. No problem. Don't worry about it. You'll be fine. All of my patients have done fine. Just sign here and you'll be on your way. Well, you trusted your doctor. You put your life in his hands because of his reassurances. He told you that this was a simple procedure and that he had no problems whatsoever doing this procedure, and you trusted him. Okay, that's what we all do, don't we? We put our trust and our lives in our doctor's hands because they have the advanced knowledge and medical training and experience, and we expect that they will do the right thing by us, and for the most part, most of them do. However, you now wake up from surgery and are now in the recovery room. You are hooked up to all sorts of monitors, all sorts of IV tubing, and you have a respirator. You can't breathe for yourself, and you don't understand what you're doing there. Your doctor told you that everything would be fine. The doctor comes over to you and starts talking to you, and you don't really understand what he's saying because it's too soon after the surgery. The doctor comes back a little while later after they took you off the respirator, and now he begins to explain what happened during the course of your surgery. It turns out there were a couple of problems during the course of surgery. The doctor comes right out and tells you, listen, I made a mistake, I'm sorry. And as a result, you had all of these complications that we had to fix during the course of surgery. You now needed corrective treatment. We had to call in various surgical consultants to come and help us to try and fix the problem. You know, it reminds me of the nursery rhyme, you know, Humpty Dumpty sat on a wall, and they had to call in all the king's horses and all the king's men, couldn't put Humpty Dumpty back together again. But putting that nursery rhyme aside, the same exact concept applies here. The doctor comes right out, and oftentimes this does not happen, where the doctor comes right out and says, yes, I screwed up, I'm sorry. This should not have happened. Let's try and get you better, let's try and fix you up and get you back to normal. Okay, well, unfortunately, because these problems are so serious and so significant, you, my friend, will never get back to normal. Your activity level will never be the same as it was. You will be permanently disabled for the remainder of your life. And now all of your activities and all the things that you could do with your family before are going to be turned upside down. You are now going to be relying on your family and your family members to help you do your daily activities. And this is a total reversal, and it's something that you are not comfortable with at all. So now, what do? The doctor has come right out and admitted to you that he screwed up. He admitted that something bad happened during the course of surgery that never should have occurred. Somebody puts a bug in your ear, one of your family members, and said, you know what? You should speak to an attorney to see whether or not you have the ability to bring a lawsuit, because I'll tell you right now, no matter what the doctor tells you and what he has told you, he's not going to pay for your kids' college tuition. He's not going to pay your mortgage. He's not going to pay for your cars. He's not going to put food on your table voluntarily. So you may have no choice because now your income is limited, because you can no longer do the things that you did. You won't be able to enjoy the activities that you once did. You are now going to have a significant problem, especially with your relationship with your spouse. Now you should seriously consider bringing a lawsuit. So you seek out an attorney. And now your attorney obtains all your medical records, has a medical expert review your records who confirms that yes, your doctor violated the basic standards of medical care, and as a result of that, you suffered significant harm and injury. Now you go ahead and start a lawsuit, and before you ever do so, you tell your attorney that the doctor actually admitted that he screwed up. And you want to know, can you use that admission at trial if your case goes all the way to trial? Can you use that admission at trial to show that the doctor actually waives his right to contest liability, that he's actually admitted it? The answer is maybe yes, and then again, maybe no. So here's what's going to happen. During the course of your lawsuit, you will have to answer questions by the attorneys who represent the various doctors and hospital staff that you have sued. Those attorneys are going to ask you hundreds, if not thousands, of questions about what occurred, as well as conversations that you had with the different doctors and hospital staff. During that questioning, you will have to tell these attorneys about that specific conversation. Why? Because that conversation is not going to be recorded anywhere. That conversation is not going to be documented in the medical chart or in the medical or hospital record. So it is critically important that you disclose that specific conversation with the doctor to these attorneys so they have a better understanding of what their client said. Because there's a very good likelihood that the doctor may not have disclosed that conversation to his attorneys, and now this may be a total surprise to the defense attorneys. Once you have identified this conversation and described in detail what the doctor said, now it's been documented. Now your testimony is preserved. And months later, I will have an opportunity to question the doctor who caused you harm and injury. And as part of my questioning of the doctor, I am going to address this particular conversation. And one of two things is going to happen. Actually, I should say one of three things is going to happen when I bring up this conversation. One, either he's not going to remember the conversation. Two, he's going to remember the conversation, but not all of it. Three, he's going to deny that the conversation ever took place. And you might be saying, wait a second, if he came right out and admitted it, and now the patient, the injured victim, says, yes, I remember, I was sitting there, he came into me, and he specifically told me the following words, and now he denies it, what just happened? What just happened is that there are clear contradictions now. The doctor says one thing, you, the injured patient, says something else. We call that a he said, she said scenario. And ultimately, it will be up to a jury to decide which of you are more credible. Is the doctor more credible, or are you more credible? Is it likely the doctor actually admitted doing this, or not? Or is this something that you, the injured patient, have fabricated to try and help your lawsuit? And that's going to be the suggestion in that scenario by the defense if that takes place. So let's say that the doctor does not recall the conversation. That can be beneficial for you. Why? Because here we have a patient, this is the one and only time they underwent this particular procedure. This is the one and only interaction they had with the doctor following the surgery. The patient is likely going to have a very vivid memory, very specific recall of exactly what happened during this potent conversation. On the other hand, the doctor says, listen, this happened 2 or 3 years ago. I've seen many, many patients since then. I've had many, many conversations with lots of patients. I just don't remember whether this conversation took place. Now, why would that be beneficial for you? Because here, on one hand, you, the injured patient, remember specifically exactly what occurred during this conversation. The doctor, in that instance, is not saying that conversation didn't happen. He's simply saying, I don't recall the details, and I don't recall our exact conversation. Now, it becomes much easier to show to the jury that what you are saying is accurate, and that you have a better recollection of that event rather than the doctor. That is a good position to be in. What happens, though, if the doctor says, you know what, I do remember having a conversation with you, but I don't remember ever admitting to the patient that I did the following things and that never should have happened. Again, it becomes a he said, she said scenario. Both of your credibilities will now have to be evaluated by the jury, and ultimately the jury will make the decision as to who they believe. If the doctor says, listen, I never said that, and I would never say that to a patient following the surgery. In that instance, the doctor has created a significant contradiction. The one instance where that scenario will benefit you is if the doctor and his attorneys try and ask the court to throw your case out at the conclusion of the discovery phase of your lawsuit. There are many instances where now, after completing discovery, where all the documents are exchanged, depositions are completed, and now we tell the court that the case is ready for trial. In that instance, before we ever get to trial, many defendants, many defense attorneys will actually try and make a request to the court to throw your case out before you ever get to trial. And the scenario where you have testified that what the doctor did, he came in and he actually admitted causing you harm and injury and that it never should have happened, and the doctor denying that he ever said anything like that. We would call that a material question of fact, meaning that it would be up to a jury to decide who's telling the truth, who is more likely right than wrong, and that it should not be the court to decide as a matter of law who is telling the truth here, or who is more likely right than wrong. In that instance, if we can show that this was a material question of fact and it had a significant impact on your case, which I believe it would because it concerns whether or not the doctor was careless, whether he violated the basic standards of medical care. In that instance, we would likely and hopefully be able to defeat the defense's request to throw your case out. In that instance, that would be beneficial if we can establish a significant material question of fact. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.